all, welcome to everybody. My name is Geneviève Bérubé. I'm the Association of Corporate Counsels Europe for Belgium. I'm the country representative for Belgium, co-country representative, along with Yves Heymans and Bruno Jean-Etienne, Bruno Jean-Etienne, who's with us today. So welcome to today's conference on commercial conflict resolution. It's a webinar with ACC Europe and Lydian law firm. Few words on ACC for those of you who doesn't know or who don't know about ACC Europe. As you can see, it's a leading in-house counsel association in Europe, and ACC Europe promotes the interests of in-house counsels across regions. And we share information, education, like webinar like today, but material as well. We offer networking opportunities and advocacy as well, while of course demonstrating innovation and leadership for the benefit of the profession. We're a chapter of a larger organization. ACC means Association of Corporate Counsel. It has more than 47,000 in-house counsels employed by over 10,000 organizations in more than 90 countries. This is only in Europe. As you can see from the next slide, we have additional statistics, and I will let you read it because you will have those slides in a minute. Actually, they are available now, but you will get them afterwards. Just one important maybe statistics is for the Benelux only, we have just almost 500 members, so we're quite proud of that. And a quick word also on our next conference, because we have amongst all of our activities, not only in various countries, but we have an annual conference. Normally it's in person, and it's in the city of Europe that varies year after year. Last year was supposed to be Brussels. It was cancelled. It will be next year. But this year we're doing a virtual conference, and the dates are there on your screen. The costs are much lower because it's virtual, so there are certain advantages. The content is, as usual, very, very rich, and you can gain CLE credits for those of you who need to register for CLE credits. This year is going to be over 3 days of a number of very interesting conferences and seminars. So I invite you to go and have a look on our website. You will have all the information there. And please note that there's a discounted rate for ACC members of 150 euros only for this year. So you have no reason not to attend. A couple of words now on Lydian. Lydian is a leading independent law firm in Belgium. It was founded in 2001 and is now driven by 90 motivated and highly competent lawyers. You will have the opportunity to test their competence today as well. Lydian provides its client large and medium-sized Belgian and international companies with prompt assistance and to-the-point advice, both in domestic as well as cross-border files. Lydian frequently handles referral cases from prestigious law firms outside Belgium and has extensive experience in commercial conflict resolution. So today we have 3 speakers. We have Annick Mottet. Annick is a partner in the commercial and litigation practice, and she heads the intellectual property team. And then we have Willems and Marijn De Ruysscher. Both are counsels in the commercial and litigation practice as well, working with Annick, but they're also in the insurance and reinsurance industry department. So a couple of words on practical information for today. So the presentation and the materials, so fact sheets, can be downloaded now right from the features of GoToWebinar. Also, they will be communicated afterwards to the participants. So if you don't have the time or don't want to download them down, don't worry, you will get them afterwards as well. During the webinar, there will be 9 poll questions. You can see them on your screen. I strongly invite you to answer those questions as they will appear throughout the presentation, because today's webinar is all about those 9 poll questions. To the Belgian members of IBG and IGE, people who do answer those questions will receive afterwards a valid certificate of attendance from Lydian that can be used to claim CLE credits from IGE IBG. After the webinar, GoToWebinar will also send you a certificate of attendance. Questions, if you have questions, use the chat function on your screen, and then answers will be provided either during the webinar or after, and if we don't have the time, they will be sent to you by emails. Last but not least, in terms of sound, normally you should be muted. Check again, your microphone should be red. If so, then you are muted. So, Annick?
Yes, thank you. And hello to everybody. And so let's start directly. So we will go through this subject matter of resolving litigation through these 9 questions. And basically, we will go arbitration versus state court. Why do you choose? The cost issue is a very important subject. We will address it a little bit more deeper. And then we will also tackle the issue of what kind of institution do you choose, what is recommended. Place of arbitration also, it's as often an issue. And then we will address the issue of mediation. Should we go to mediation? What is the advantage of mediation? What is your experience in mediation? Particularly with lawyer, as we are now, we have an obligation to advise and to mention that to our client when we have a litigation, that it's a way to solve the issue also, and so that it's compulsory for us to inform you about that. And so we will tackle afterwards also quite of a maybe not that known matter, but it's binding third-party decision. We will address briefly about the project of a Brussels International Business Court, and we will also tackle the question about third-party funding. But Marijn, let's go directly to the first full question, where we would like you to, you will have on your screen, and then we will ask you to participate and to just tell us about why do you consider arbitration instead of state court, whether it's for the confidential nature, duration, finding a decision, except, of course, if it's annual on limited ground, and whether you choose it because you have a specialized arbitrator, a neutral arbitrator, and or because of the reason of cost. So Azure, you can, so we invite you to reply, and then we will show you the result of this poll question, and we will address in more details about the result of the polls. There was very straight reply, and it's quite obvious that 48% of you choose it because of the confidential nature, 62% of you for duration purposes, 21% for final decision motivation, and specialization is also obviously, neutrality is obviously a very important element to decide, and cost seems a little bit accessory to the decision making about going or not to arbitration. So let's go to the various subjects of these, and can you comment a little bit on the and Marijn on these different aspects? What about confidential nature was obviously something very important for the audience.
Absolutely, Annick, and it's not I think a coincidence that we see so many votes on confidentiality. Confidentiality is very often combined with arbitration. I think what is very important here to realize is that I wouldn't necessarily call arbitration confidential. I would call it private. It's private. It's closed. The press doesn't come into a hearing. You cannot have public in the hearing. But it's not necessarily confidential, and that is really an attention point. You have to really check the applicable arbitration rules. Do they provide for confidentiality? If so, then it's very often a general clause. This arbitration is confidential, fine, but what do you do if the other side violates that obligation? So I would say as a general tip, be very careful. If confidentiality is really essential for you, if you're going to share confidential, sensitive business information because you need it to present it as evidence to the arbitrators, I would put into place an additional framework, an additional NDA or something similar, and not just rely on the fact that it is arbitration, so it is confidential. It's private, it could be confidential, but in general, it is not necessarily confidential. So I think that's a major attention point.
Yeah. So about duration.
Yeah, duration. I would say that's the 62% voted on duration. It's a bit connected, I would say, to the third point, namely that it's one shot, and normally you do not have appeal in arbitration. So if you choose arbitration, it's one instance and there is no appeal. You can have annulment, etc. But on the merits, you only have one case. I would say, from our experience, arbitration is not necessarily faster than first instance court litigation. But since you don't have the appeal, it remains with this first instance, let's say. What I think is very important to realize here is that the duration is to a large extent dependent on the party's own decisions. If you as a party say, I want to file at least 2 submissions and I want to have 2-3 months to prepare them each time, yeah, then automatically you already end up at almost a year of arbitration. If you say, well, let's agree on only have 1 set of submissions and we do it in a very short time frame, you could arbitrate in 6 months. So a lot depends on what the parties want themselves. Of course, availability of the parties, inside counsel, business people, but also, of course, outside counsel and arbitrators. So a lot is under the control of the parties, which is, I would say, typical for arbitration. So it's not necessarily faster than court litigation, but you do have more control over it, I would say, compared to court litigation.
Yeah. But we have also experienced some institution has also set up some expedite proceedings, and we experienced one of the first one by the ICC, and it was really a success because in 6 months we had our case settled. But of course, we can choose this for more like smaller case, and where the party also are willing to apply for that. But it was quite an experience. And so that with regard to the another factor, and very important, and the most important one that we have seen in this poll question is the possibility to appoint specialized or what we say neutral arbitrator. Can you comment on that too?
Absolutely. Well, neutral, I would say arbitrators, obviously, they have to be impartial and independent. So it's not because you can choose someone that they necessarily will decide in your favor. But I think it is a major advantage, especially for highly complex cases, that you can really appoint, well, if it's a multi-party tribunal, that you can appoint your own arbitrator, or that at least you can influence the choice of the sole arbitrator or of the presiding arbitrator. That is really important, because otherwise you can end up in court and you don't know who you will get. It can be an excellent judge. It can also be a judge that doesn't know the very specifics of your case. So I would say, depending on the subject matter specialization, it is really important to have the specialized arbitrator. And in general, of course, everyone wants to win their arbitration or the litigation. But if you get a well-reasoned award, we get the impression it's easier to accept from the point of view of the client that, well, or they lose or they don't win everything as they had hoped. If you have a very good reasoning and intellectually you can understand what the arbitrator has decided, it's easier to accept it than if you get a decision, for example, from a court and, well, the judge just didn't understand the question. So I think that's indeed a very a big advantage point of arbitration, that you can go to have these specialized judges, arbitrators that the courts just cannot have always for very specific matters.
Okay, yes. Do you want to comment, Geneviève, on your experience?
Just one point that a colleague of mine used to mention, a colleague from Asia in the past, about some Asian countries. Apparently, it's much more difficult in Asia to have courts of a certain country to recognize a judgment from a foreign country, even if it's a neighboring country. So the better choice in Asia, at least in several Asia countries, is to go for arbitration, because it's much easier to enforce that decision afterwards than court judgment. So that would be in international disputes.
Okay, yes. And we saw that in fact cost is quite not that essential, at least among the audience. Although it's sometimes a point raised by the most of the people that to avoid arbitration because of the cost. And then we have a more specific question about cost. Marijn, if you want to go to the next slide. So that in fact is really cost a factor to consider or not consider in arbitration. And we have mentioned several views on that, whether what we would like to know about what you think. Obviously, it's not so important in your decision, but if you choose arbitration and do you think that it's worth the cost, obviously, the cost is too high, it's only limited for high value cases, or arbitration is much too expensive, or arbitration it works for high confidential cases. We have seen the nuance with Marijn about confidentiality and privacy, and or you have other reason why you want to avoid arbitration. So let's have the poll amongst you. Again, it's very clear tendency. Arbitration always was the cost 16%, 13%. Arbitration, it was the cost for high value cases, obviously, and that's what we have the feeling that we always provide for arbitration for high value cases. Arbitration is always too expensive, so that you have experience, obviously, that it was the value, and then was the cost of high confidential case. And I try to avoid arbitration for other reason. Only 2% of you has reply, and then it would be nice if those who have made some other comments can make it in the question or in the comment in the chat box. Again, Jo and Marijn, what can you comment a little bit on these results, which are very clear among the audience?
Yes, and not unexpectedly, I would say. I mean, obviously, arbitration, there is always a certain cost to it because you have to pay your specialized arbitrators. But as we have seen in the previous poll, that's exactly what users often want. They want to have these specialized people. So obviously, you need to pay for them. I would say in general, because I'm not going to go into too much details, but it's important to compare institutions. The ICC is very renowned specialized institution. They're more expensive than more regional institutions. So I would say compare that, and if you're drafting a contract, see where you would end up. Often the cost is calculated on the value at stake. It's not always the best way to calculate it, but that's often used. It doesn't mean that arbitration is all an option for smaller cases. I mean, I've been appointed arbitrator in smaller cases myself. You get a fee of 1,500 euros or 2,000 euros for such an arbitration as an arbitrator. Well, it's more symbolic because you can spend quite some time on it. So it's not necessarily expensive for the users. I think I would invite everyone to check on the different websites of the institutions. You can calculate that there very quickly where you would end up with tribunals. I would say a big difference, but I think there you can also add something. A big difference or big advantage or disadvantage, depending on how you see it, is that in arbitration you can have this recoverability of your lawyer's fees. You could, in principle, claim them from the losing party. It's not a certainty that you will get them as a winning party, but it's an option. And that's, I would say, a big difference with court litigation, where you often have a limitation there.
Yes, that's correct, Marijn, because in court proceedings there, you cannot, in principle, in Belgium at least, not recover your lawyer's fees. So even if you're the winning party, the losing party does not have to reimburse all the lawyer's fees and costs to the winning party. What you can recover is the fees of technical assistance, insofar as this was necessary in the court proceedings. For instance, the fees of an accountant or an architect, which was necessary in order to defend or win your case. But the only thing that you can recover in Belgium then, in Belgian court proceedings, is then the so-called procedural indemnity, which is a fixed contribution per instance for the costs and fees of the winning party's lawyer. And this procedural indemnity depends and is based on the value of the claim. And to give you a rough idea, for a claim of 100,000 euros, the procedural indemnity is 6,000 euros. For claims above 1 million, it's 18,000 euros. It can be reduced and it can also be doubled by the court, but that's the maximum. So 36,000 euros for claims above 1 million. So in general, your lawyer's fees will not be fully compensated or reimbursed by the procedural indemnity. So arbitration, where you can recover all the lawyer's fees, is there to your benefit, or if you're the losing party, of course, to the disadvantage. Other legal costs in court proceedings are relatively limited, like the service of a bailiff. The only thing what people or clients often forget is the registration fees of 3% on the amount that it's awarded to the other party. That's a tax which is imposed by the Belgian authorities, and it's some kind of tax in order for the costs of the courts, and which has to be paid also. And this comes afterwards, after judgment above 12,500 euros. You have to pay a tax of 3% of registration fees, which is not so in arbitration, where you of course then have to pay the fees of the arbitrator. So in general, court proceedings are less expensive, but it depends on which side you are.
Yeah, and also you have to sometimes to take into consideration translation costs in court proceedings, where you don't have necessarily the issue if it's in English and the arbitration or the correspondence in English, you don't have these costs also. And sometimes it can be very, I just won a case basically because in the court proceedings, I just require the translation of all the documents submitted by the other party in English, and they file all American patent record, so it was a big, huge fuss, and they didn't want to spend the money for the translation. So we won the case basically on that
yes.
basis. So we were quite lucky in a way.
That's correct.
Yeah. You want to add something, Geneviève?
Just a couple of costs that people don't think of also in arbitration, because in court, you go to the courthouse and the rent is already paid for. But when you go for arbitration, you have to find a neutral place. Often it's a hotel meeting room, but you have to pay for that. So depending on the length of the arbitration, there's a daily cost for that meeting room. Then it comes with the food, the internet connection, and then if there are traveling costs on top of that, then those are costs that sometimes people don't think about. Another point that
sorry to interrupt you, but nowadays we can have arbitration through GoToWebinar or a Teams.
That's true. That comment was pre-COVID.
It's the rethinking about, is it really necessary to travel? Look, we have a seminar. What we miss is a little bit the interaction with the audience. But in a smaller group, I think that it's feasible also to do it. It's maybe a cost that will be avoided in the future.
Agreed. I think we're in an era where everything is changing. And I'm curious to see how things will be post-COVID. I mean, we've seen, everybody remembers the cat. We've seen the audience in the US, for example, court audience by Zoom. So yes, indeed, people don't travel anymore. But those, if it has to be in person for some of the reason, those are costs that pre-COVID we used to think, and maybe post-COVID we would think of. Bruno, during our discussion, also Bruno Jean-Etienne mentioned that we have to think sometimes of the advantage of arbitration being the last and the only resort court or tribunal, I should say. So even if some costs could put you off for arbitration, think of judicial court, where you might have to go to appeal and higher and pay for all the costs, and meaning your lawyers as well. So yeah, it's not a straight answer, I think.
So you really have to balance the pro and con on the basis of the different question and mention that we. So let's go also, because another issue is to beside the cost and so on, to choose whether are you choosing a specific arbitration institution like ICC with the London Court of Arbitration, or more like local institution, which are usually a little bit cheaper but as good as the ICC or London Court, or like CEPANI or the German organization, or the Scandinavian also is quite successful, or other, or do you prefer ad hoc arbitration? And so we would like you to share with us your preference amongst these options, and what do you do usually in your experience? What do you use as an institution? So 31% of you would use ICC, which is of course well reputed. The London Court of Arbitration is less 7%, and local institution is obviously the preferred choice for most of you, and the other, and there is 16% which would prefer to go for ad hoc arbitration. So I guess that we can briefly comment on this, Marijn.
Yeah, absolutely. Well, it's interesting to see. So indeed, most would go to local institutions. I mean, timing is obviously too short to really start comparing institutions. They all, let's say, have their particularities in the rules. As I already mentioned, one of the differences is cost. So I think with smaller cases, you would not immediately go to the ICC, even though they have expedited rules with smaller fees. But still, I think that would be for the bigger cases. I think one of the advantages of local institutions like CEPANI in Belgium, and I think a lot of participants agree, is that they do have a knowledge of, let's say, the local arbitration market, which is very convenient. For example, if that institution needs to appoint an arbitrator with knowledge of the local law, etc. If you have an arbitration institution in Belgium that would need to appoint someone in Dubai, for example, that's already less easy than if the ICC would have to do it, because they have contacts and networks all over the world. So I think it's indeed a very good idea to let that depend on the type of case that you have. I'm a little bit surprised with the ad hoc arbitration. We do see quite a lot, for some reason or whatever, that indeed ad hoc is still used quite a lot in contracts. For example, in the insurance sector, they like to use it a lot. I don't really understand why, because yeah, we always see it takes much more time, it's much more complicated compared to institutions where you always have the fallback of the institution taking a decision. Ad hoc, yeah, you have to go to the court if the parties don't proceed. I myself, I was appointed last year in March, just before the COVID, as an ad hoc arbitrator in a tribunal of 3. And well, let's say we are 1 year later and the arbitration still has to really start because it took ages to find a presiding arbitrator. Yeah, none of the parties went to the court to really enforce that. So it dragged on, which you would never have in an institutional arbitration. And I believe Jo also has some experience with ad hoc, which, well, wouldn't really make a favorite of ad hoc arbitration.
No, definitely not. It's a negative experience because in ad hoc arbitration you have no basic or procedural rules, as you explained, and this is perfectly for a party who does not want to bring a court to trial or to have a decision on it. It's perfectly as a delaying tactic to start or to just ignore and not cooperate in an ad hoc arbitration, because it's easy to delay the whole case and the matter. It starts with the appointment of an arbitrator, and then afterwards also with the procedural timetable that you do not agree on, and it makes it necessary without basic rules on which you can rely, that the case will be delayed. And also the ad hoc arbitrator will also be in a difficult position because he can also not rely on any procedural rules to take a decision. So I definitely recommend to make use of an institution, because then you have some basic and procedural rules at your disposal, and it makes it more easier.
Yes, of course. You want to comment, Geneviève, or we can go directly to the place of arbitration question? Okay. This is another issue also, but it might be not more very relevant in the future. But of course, for the time being, it's still recommended to have that mentioned in your contract. But now we will see probably another alternative is to have a video conference arbitration. Our question is to see what is your preferred place of arbitration, and this is another poll question on which we would like to have your view on it. Whether it's a place of business of your own company, whether you choose the contract performers, a neutral, so-called neutral place like Zurich or Paris or Singapore because of the experience and reputation, or whether a place of business of the arbitrator institution. Let's go for the poll. I think that Azure, you can go quick on this because it's not that complicated. And so what are the results? So obviously a place of your own company and is the main place where you prefer to go for arbitration. Place of the contract performance is only 10%, and a neutral place, as we would say, is not necessarily taken, but the place of business of the chosen arbitration is also a very common place. So do you want to comment briefly on this? Not too long, because we do not want to.
I will just make two small comments. I think what is important to realize, because of course choice is free, so whatever parties like, but what is to realize is that if you choose the place of arbitration, or also called the seat of arbitration, you determine the legal framework, you determine the Arbitration Act that is applicable on your case. So it's not just a place where you would like to go, but it's also really the local arbitration law that will be applicable on your case. You may need it, you may not need it, but that's important to realize, especially if that would not be aligned with the applicable law. If you have a contract governed by Belgian law, you choose for Zurich as place of arbitration because you like Zurich in summer. It's good, perfect. But you must realize that if you then you would have to take two lawyers or two law firms, one with knowledge of Belgian law because that's applicable on the contract, and then you would need a lawyer, at least in support, in Zurich, who knows the local arbitration law. So be careful if you choose place of arbitration. I would try to align it with the applicable law if possible, but it can lead to additional costs, I would say. And in the end, indeed, in this virtual world that may proceed, perhaps parties don't even travel anymore to the place of arbitration, but still there will be this legal connection to this place, which can lead indeed to costs if you don't choose this wisely.
So I think that we have made the tour of the arbitration side, and now we will switch to mediation and as an alternative dispute resolution means, and we would like to share with you what is your experience with that. Did you have already experienced that, whether you don't have it or you have not been involved in mediation? Ashu, you can ask the question. So obviously there is again clear tendency. Mediation is not yet so common, but or at least the question was that you did not, 2% of you have experience, but it didn't lead to an agreement. 22% of you have experienced it, but it led to an agreement, so it was quite successful. And 76% have not been involved in mediation yet. And so that obviously it's something we still have to develop. It depends, of course, in Belgium, where the most of participants are coming, court proceedings are still quite accessible, and so it's mainly probably also a reason why people do not necessarily see the advantage. And also, but another question linked to this question is to see, in fact, what are the advantage of mediation compared to ordinary settlement negotiation? And because, of course, most of the case we are settling, and sometimes there is a little plus in going to mediation. So what we would like to first also share with you, it's your experience, to see whether you believe that mediation has really advantage compared to settlement negotiation because of the independence and C of the mediator, which increase the chance to reach an agreement. Mediation is also always confidential. Mediation agreement can be made enforceable by a court, which is not necessarily the case for settlement unless you have a court proceeding and then you enact and you have a judgment. enacting your settlement, but usually it's not often the case. And mediation does not have any advantage whatsoever, according to you. So let's reply to this whole question. And then obviously, again, very clear answer. The fact that you have an independent person intervening in the litigation make it that it can be a success. And it's obviously the main advantage of mediation. And then mediation is always confidential, intervene only for 14% of you, as well as the fact that it's immediately enforceable by a court order. And then very little people consider that there is no advantage in such. Jo, you want to comment a little bit on this aspect of mediation?
Yes, because I think the audience, the answer, the first A, independent mediator increases the chance of an agreement, is by far the most important factor, I think, because I think parties, when they are assisted by a lawyer, they can also reach a settlement by confidential negotiations. But it depends mainly on the third party, the mediator, the person of the mediator, how he's perceived by the parties, whether the mediation will be a success or not. In my experience, I was involved in 3 or 4 mediations, and only one was successful, and this was basically based on the approach by the mediator and also the respect that the parties had for the mediator. And this is very important in order to come to a success, I think, and it's often also something to take into account when appointing a mediator, the background of the mediator, also his expertise in the matter. That the mediation is always confidential, that's true, but also the parties can reach conclude a confidentiality agreement even outside a mediation. And in Belgium, at least, when the parties are represented by their lawyers, they can also communicate easily by confidential correspondence between lawyers. So this also facilitates settlement negotiations. That the mediation agreement can be made enforceable by court order, that's a big advantage. But there we have to also additionally state that this is only when the mediator is an accredited mediator. So you cannot appoint every, for instance, lawyer to become a mediator or to mediate a case, because only the accredited mediator who has a sort of permit can also then render or conclude an agreement which can be enforceable. So I think that mediation has certain advantages, but mainly in my experience, in a relation between parties who are assisted by lawyers, for some reasons the parties or the lawyers, that's sometimes also the case, cannot get along, and then they need a third party to reach a settlement. Then I think that mediation is certainly worth a try.
Yeah, it removes the emotional aspect of the litigation sometimes, to have an independent person to get in. Also, as a lawyer, we have to be independent and have try to have a helicopter view of the situation. Also, it's our role, but sometimes it helps to avoid this emotional aspect, or sometimes when after a while, or when people are changing within the company, then it starts to be more easy to settle. Also, sometimes when you have more that the business purposes up front and not the subjective aspect taking into consideration. So let's, because there is also another dispute resolution mechanism, which is maybe less known, and that is a binding third-party decision. It's quite, we have experience in this more and more, and we would like to share with the audience what is your experience in that, and do you consider whether this is a good alternative to the other dispute resolution mechanism. The first is binding third-party decision is your preferred choice compared to arbitration or mediation. Arbitration or mediation are your preferred choice, or you are not familiar with binding third-party decision. Let's go quickly through this question. Yes, so obviously the results show that a lot of you are not that used to that, so that we will tackle a little bit what it is and what are the advantage of such mechanism binding third-party decision. Can you comment on that, Marijn, I think, or it's you.
Yes, thank you, Annick. No, what we expected a little bit was that 83% of the audience is not familiar with binding third-party decision. And that's also something useful. You do not only find the slides as handouts, which you can download, but we also added some fact sheets on arbitration, mediation, but also on this binding third-party decision, in which we set out the details and the mechanism of this legal mechanism. So what is a binding third-party decision, and what's the difference with, for instance, arbitration? A binding third-party decision implies that the parties agree that the third party, who's not an arbitrator or a judge, will provide a binding assessment not on the full dispute, but on one or more aspects of, and it can be a factual or legal relationship. It has many applications, and when I give you an example, you will then say, okay, that's something I know. It's, for instance, determine the value of the shares, which is often used that a third party is appointed an accountant to determine the value of the shares. So it's often used in the context of technically complex contracts and also in international trade. It has a legal force of an agreement, so parties can agree on it, and it has also to be respected by the parties, but also by the court. So if the third party, not only the agreement itself, but also the decision rendered by the third party has to be respected by the court, and the court only has a marginal review to look whether the decision was not unreasonable, was incomplete, does not contain gross material errors. But in principle, the judge cannot redo the work of a third party. What's the difference with arbitration, as outlined already? Even when often we see, and I have a case pending now where there's clearly, it's an arbitration agreement and there's an arbitrator appointed, but the appointment was only related to investigate the cause of a fire. And it was the person appointed was a fire expert, but he was obviously not an arbitrator, because an arbitrator will finally settle the whole dispute, the legal dispute between the parties, by arbitral sentence. And this is not the case with the third party of binding third party decision, where it relates more to a factual assessment or a legal assessment, which will not full and final settle the matter between the parties. And if one party does not agree, it can still go to the court or to arbitration, depends on then the competition clause, but then the court or the arbitrators can still declare the decision of the third party invalid. So the big difference is that after a binding third party decision, you still risk to go to court or to go to an arbitration in order to finally settle the dispute. So sometimes it's useful, but if you parties do not agree on a decision when it's not clear, and again, it's important, the third party that you appoint, that he is really competent, that he does the job properly, and otherwise you will end up in court. I know I have the case where I was referring to with the fire expert. This case, this binding third-party decision has taken almost 1 year, 2 years before the decision was rendered, and we're now before a court disputing the decision. And it will take some time because there was also a discussion between whether the courts would be have jurisdiction or arbitration in the Netherlands. so the case is delayed before the court. So it's a perfect example of what we are discussing right now. But it's an alternative that you can consider, especially for the determination of the value of the shares.
Yeah. Okay. So it has its advantage, but of course, if the party and it's like in all litigation, if you don't have a little bit of willingness to solve the issue from both sides, it can be pretty messy. And let's go quickly to because we heard a lot, there was a big announcement about the Brussels International Business Code or similar code. And so what is the, what is it? Did you ever heard about it? Did you know that there was a similar other one, or did you never heard about these alternative code, which is obviously state code, but international, so that it would deal with international. So let's go quickly to the result. So you have heard about the Brussels code and not really about the other one. So Marijn, can you quickly comment, because we have another quite interesting question to end up this seminar. So
absolutely. Well, I'm quite surprised that so many people heard about Brussels International Business Court. It shows that there was more attention to really promoting it and marketing than really putting something in motion. It was an initiative of the previous government. They wanted to create this special ad hoc court in Belgium as a competition to, well, on the one hand, London, and with the Brexit coming up at that time. So they wanted to compete, get some business, get some international litigation from London by offering court services in English, and to compete with arbitration, it would also be without appeal, so also one shot. It was introduced in Parliament, but nothing happened, and the current government didn't do anything with it. We saw different other EU countries on the continent, let's say, taking the same initiative, thinking that they could draw international business from London or international litigation from London. For example, the Netherlands, they have in Amsterdam this chamber of the court, and since the 1st of January 2019, you can litigate in English. I've just checked on their website this morning, and they have 9 judgments rendered since the 1st of January 2019. So I wouldn't really call this, let's say, the biggest success. Also in Paris, for example, I've seen that the Court of Appeal has a so-called international chamber. Well, it's not really, let's say, a full English or full international chamber. As far as I've seen, the procedure is still in French, so all the procedural documents are still in French, but you can file exhibits in English. Well, something you can
so it's not really a big difference
since very long.
Okay.
Plus,
yeah.
you can, let's say, if you're a foreign lawyer, you can plead in English, but that's it basically. So yeah, it was a big initiative, but I don't think it's really very successful.
So let's go quickly to the last but not least question. And would you consider using third-party funding? Because we heard a lot about it, at least I have, but not experience it very concretely, except for consumer issue or very essential. We can imagine in patent also cases where you want to save, but the owner doesn't have any money to that. So what is your experience? Can we go to the poll question directly, so that I have used third-party funding? I have not yet used it, but I will consider it, or I'm not familiar at all with third-party funding. Most of you obviously are not familiar with stuff. Can you briefly, Jose, no, it's Marijn, I think, or I don't remember, sorry. One of you can comment. What is it exactly? What can you tackle? It's Marijn, yes.
I can say something about it, absolutely, but otherwise.
Yeah, 2 minutes max.
Well, No, I mean, third-party funding is something we have seen, I think, at least 10 years, if not more, in arbitration, where you have these specialized companies that really look for cases which they can fund, and then obviously take a percentage on the claim if they win. So it's basically the alternative of lawyers' arrangements where they would, let's say, work on a success fee, which is not completely, or it's not 100% allowed in Belgium, but in other countries it is. But you have really specialized companies and don't do anything else than that. We see it sipping through in litigation. In Belgium, we have two commercial players on the market that offer that. Well, we get commercial advertisements from them from time to time, but we don't really see it in practice in Belgium. I think because litigating is not that expensive in Belgium compared to other countries. I mean, the principle is always that, or as a claimant, you don't have the money to start a litigation, but you have a good case, but you don't have the money, especially for arbitration, which requires an upfront investment. Or you do have the money, but you just don't want to spend it, and you rather just, you know, hand it over, or at least financially, to a third party, knowing that they will take a big share afterwards, but otherwise you wouldn't, let's say, continue the case anyway. Theoretically, you could also get yourself funded as a defendant, but I think that's more difficult. Then you would have to have a counterclaim. Just one point I would add to that is that it is getting some attention. For example, the updated ICC rules that entered into force earlier this year, they now contain an obligation for the parties to be transparent about the fact that they are being funded by a party that has a stake in the outcome. It can be the lawyers themselves, but it can also be a third party. So there is, let's say, an increase in requirements for transparency, because it could create some kind of inequality. But it's sipping through on the market. But I would say in Belgium, it's not really very active yet, and I think that has to do with costs of litigation.
Okay, so it has to be seen. I think that we can close. We have tackled all the main issue. We don't have that many questions, but we had one question regarding the cost. Let's see. Yes, to see whether we can negotiate, in fact, the cost or the fees of the arbitrator.
Correct.
Yeah. So
correct.
what is it? What can we do that ad hoc? Maybe, but the other, I don't think so.
No, and maybe I will start, but then also immediately pass the floor to Marijn. I did a reply all to that question already, so I said that it's often fixed. I think definitely for an institution that it will not be possible to negotiate the arbitrator's fees. In an ad hoc arbitration, then it can be differently, and it can be agreed from the start. But I don't think for other institutions, at least, that it will be possible to have a lot of negotiation margin about it.
Okay. So I guess that we can. I just check whether there was any other question. No. So I guess that we were clear. Or we will see. Anyway, don't hesitate to contact us. Thank you for your audience. And at the end of the presentation, you have all our contact details. You can also download all the fact sheet if you want to go into details on a specific subject: arbitration, mediation, third-party funding, or binding third-party decision. And I thank you also for ACC to invite us to collaborate with them for this seminar. And our next seminar, if you are interested, it's about outsourcing on 27 May. I let you close the session, Geneviève.
Very quickly, thank you all, and thank you in particular for Lydian, your professionalism as usual. I mean, we're right on time, so people will be able to go to lunch without any delay. I personally learned a number of things today that changed my preconceived ideas about certain aspects of arbitration. So thank you very much. For our participants, I just want to remind you that our next event is really the big event is the 25th and 27th of May. It's our annual conference. For all other events, please, by all means, go on our website. You will see all events, not just here in Belgium, but all across Europe. And it's very worth it. If you're not yet a member of ACC, consider it. I think it's worth it. One last word, it's a personal goodbye from me. I'm stepping down as a Belgian country representative of ACC Europe. I introduced you earlier to my replacement, my colleague, Bruno Jean-Etienne. I hope that you will have the opportunity to meet him in person. He's a very fun and lively person, and he will be completely dedicated to carry on our initiatives for ACC Europe in Belgium and the Benelux, and maybe beyond that. So again, thank you very much for your participation, and bon appétit.
Thank you. Bye-bye.
Thank you.